Hello and welcome. You are listening to an informed take on current events brought to you by law students and staff of Queen's University Belfast. This is LawPod.
I'm Alina Utrata, and I'm a master's student at Mitchell Institute, and we're here today in the recording studio with Dr. Kevin Brown, who's a lecturer at Queen's University Belfast School of Law in Criminal Law and Criminal Justice, and the LLB Program Director for the School of Law. Dr. Brown's research has focused on the socio-legal explorations of the regulation and governance of public spaces, victims' rights, and criminal justice. Thank you so much for being here today with us.
You're very welcome, Alina.
So today we're going to talk about the criminalization of homelessness, and in particular, the increasing use of public space protection orders. I'm going to start off by reading a quote by Simon Dudley, who's the leader of the Royal Borough of Windsor and Maidenhead in the run-up to the royal wedding. And he said, and I quote, "A large number of adults that are begging in Windsor are not in fact homeless, and if they are homeless, they are choosing to reject all support services. It is therefore a voluntary choice." Now, this is a perception or attitude around homelessness that gained a lot of attention in the run-up to the royal wedding, as Simon Dudley publicly worried about how visible homelessness would impact perceptions of the town. And your work, Kevin, has dealt with how local councils have addressed visible homelessness in public spaces. So what did you think about his remarks?
Yeah, it was interesting to see how much attention his remarks got, I guess, because it was in the context of the royal wedding. And what he said it sounds potentially extraordinary to hear someone talk about people who are homeless making a voluntary choice to be so. But the attitudes that he expressed, although they got him into some hot water with his fellow councillors, are actually quite commonly held throughout the country. And indeed, although action wasn't taken against the homeless in the run-up to the royal wedding, as he suggested, because he suggested there needed to be action to be taken against rough sleepers and beggars because it would be bad for the borough's reputation and it wouldn't be good for tourists to have to see the visible homeless on the streets and have to encounter them. So although he didn't get his way in action being taken, many local authorities up and down the country are introducing legislation to remove those who are rough sleeping or those who are begging from public spaces.
So there's a historical resonance to these attitudes and laws towards homelessness and poverty that dates back centuries. Could you tell us a little bit about that?
Yes, so as you say, we'll be talking about public spaces protection orders later on in the podcast. And they were only introduced in 2014. But legislation governing the homeless, particularly the visible homeless, so those begging, those rough sleeping, has a long history, a long pedigree in the United Kingdom. So we talk historically about vagrancy legislation, and this legislation goes back to the medieval period. So we've had it for over half a millennium. In the Tudor period, they introduced legislation governing the public homeless in the sense of targeting those who were seen as the undeserving poor. So we very early on had this sort of divide between what was seen as the deserving poor, who society would be compassionate towards, and the undeserving, those who were seen as at fault for the state in which they find themselves in. That might be because they were seen as being lazy, or they were seen as bringing about their own fall due to alcohol abuse, due to refusing to work, or committing criminal acts to support their lifestyle. And this historical divide between the deserving and the undeserving, which was embodied through vagrancy legislation, has continued at different levels throughout the last 500 years. And the legislation has been reformed at points. We've had more of a welfarist approach. We had sort of the primitive welfare state was based on the poor laws, so introduced during the Elizabethan era. and these provided some care, some support for the most poor and destitute. But they were accompanied by the vagrancy legislation, which said, yes, we will look after the deserving, but not the undeserving. And continuing up through the decades, through the centuries, legislation was being reformed. There was more rights occasionally for and support for those who were poor, but there was always an element of targeting those people perceived to be the undeserving poor. And what we tend to see is through the years, whenever there's an economic downturn, attitudes harden towards the poor, and there tends to be fresh legislation intervening to curtail the rights of those who are seen as impeding on public space. We have still in force in England and Wales vagrancy legislation that dates back to the 19th century.
Wow.
It's still in force and still used to this day. And that criminalises begging and rough sleeping. Now, of course, we saw the development of the welfare state in the 20th century, particularly after World War II, and the creation of the NHS, the welfare safety net for those who find themselves out of work. And that reduced inequality. It was an important step forward in having a more equal, more democratic society. But of course that began to be undermined from the 1980s onwards with the rise of Thatcherism and neoliberalism. And alongside that, we have increasing attacks on the poor, this idea that, again, that it's the poor's fault for finding themselves in the position that they have done. And with the economic downturn of the more recent one of the Great Recession, as it's sometimes called, again, we've seen in the UK and indeed in other Western countries these attacks on the what's seen as the undeserving poor again. It's maybe in today's discourse it could be chavs, is a term that's sometimes used, or neds, whatever part of the country you come from. But then we see also the government endorsing this view that people are responsible for the situation in which they find themselves in. So through the decades, through the centuries, this resonates through this idea of, yes, occasionally we will view the poor as deserving and in need of support and protection, but particularly when it comes to public space, this idea that the poor, if they're intruding on the majority in society and their use of that space, they can very quickly become to be seen as undeserving and worthy of criminalisation.
So you talk about this distinction between the deserving and the undeserving poor that goes back literally 500 years. And we see that sort of reflected in the rhetoric today of people saying, the poor, they don't give them money because they're all alcoholics, or they're just going to spend it on drugs. Do you think those attitudes are a reflection of those older laws, or are they based in what we like to think of as a modern sense of reality, of statistics, of this is actually a reflection of what's going on?
I think that's a good question. I think we have this populist response to poverty that resonates throughout the centuries, and of course it takes slightly different form each time, and the terminology differs in each historical period, but there's definitely a resonance, and that is, instead of saying as a society, how do we create a more equal society by working together and supporting one another, it's actually, there's certain elements of our political class who will encourage us to divide amongst each other, to apportion blame instead of supporting one another. And the way of apportioning blame to the poor is to say, well, it's your own fault. If it wasn't for, again, drinking or taking drugs or other poor lifestyle choices, you wouldn't find yourself in the situation that you do. And it's in a convenient way for the government, instead of focusing on more structural issues that are the causes of poverty, such as limited affordable housing, for example, or curtailments made to welfare benefits. And for example, we've seen a report out just, very recently talking about how people are forced to wait weeks or even months sometimes to access benefits. And so for the government to deflect away from that, and particularly in this age of austerity, it's about encouraging us to blame one another. And the visible poor, who tend to be those who are in the public spaces, the homeless, including those who are begging or rough sleeping, can be an easy target.
So you don't think poverty is a moral failing?
I don't think it's a moral failing, no. I mean, it's true that there's a combination of, in terms of why people end up homeless, and of course there's different definitions of homeless. I think today we're focusing on the street homeless, but there are within the broader category of homelessness, for example, we would include those who are maybe forced to stay in temporary accommodation, which there are many individuals and families in the country who are doing that at the minute, or those who are maybe what would be described as sofa surfers, who maybe have nowhere to stay, they're not able to afford to rent accommodation for themselves, so they're moving from sofa to sofa of friends and relatives. But then you also, of course, then have the street homeless as well, and they're the most visible manifestation of that. And when reports that have looked into what, by Crisis and other charities, what is causing and what are the causes of street homelessness and homelessness more generally, it's actually it includes those big structural factors that, of inequality and limited access to benefits that are the main drivers. But there are personal circumstances as well in terms of addiction, whether it be to alcohol or to drugs, relationship breakdown, individuals who suffered domestic or sexual abuse and have had to flee their homes because of that. So while there may be personal factors mixed in with those structural factors, that doesn't mean that we apportion blame to those individuals or hold them responsible, because it's still the state's obligation to support those individuals who are having personal difficulties, who are having those complex complications added to their lives that makes it very difficult to maintain a home.
So, public space protection orders, or PSPOs. Sounds pretty innocuous and innocent, but tell us why and how they're being used.
Yeah, so PSPOs were introduced in 2014 by the then Conservative and Liberal Democrat coalition. And it was legislation they were introducing to reform the Labour Party's antisocial behaviour provisions that they introduced. I suppose the most high-profile provision introduced under Tony Blair was the ASBO, the Antisocial Behaviour Order. So that legislation was replaced in England and Wales by a series of, and introducing a series of new interventions, such as criminal behaviour orders, antisocial behaviour injunctions, and also what we're focusing on today, the Public Spaces Protection Order, or the PSPO. So they're relatively recent. They were introduced in 2014, as we've said, and they give local authorities in England and Wales the power to issue an order. So it's not a court order, it's the local authority that issues the order themselves. And this order will govern a certain section of public space, a particular location within that local authority area. They can demarcate for themselves what the area is, how extensive. So in some cases it may be one or two streets. In other cases, you will see entire town centres or entire towns or cities covered by the PSPO. It's really up to the discretion of the local authority. And what they do then is they decide on not just the spaces and the locations to be covered by the PSPO, but the behaviour. What activities are they going to target? So there isn't a set list of activities. The central government had said effectively was in terms of localism, its localism agenda. So they wanted to trust local authorities to work with communities to decide what were the types of behaviour that were impacting on quality of life in their locations. And that was one of the key phrases in the legislation, quality of life. And the argument was that local authorities would make the decision in consultation with the communities to say, well, we're going to target certain behaviour and that will improve those public spaces for the users of those public spaces. Now, the government initially did not talk about targeting homelessness, but increasingly local authorities have decided to use the PSPOs to target activities associated with homelessness. Now, a condition of a PSPO would not say that would not just mention homelessness, it would mention activities associated with homelessness. So that would be begging, rough sleeping, and loitering would be the key ones. And the local authorities have discretion exactly how are they going to define what's covered. So is it begging in general, which we see in some local authority areas? Is it so-called aggressive begging? Or in one local authority area that I looked at, their PSPO covered passive aggressive begging, which was an interesting choice. Do they cover rough sleeping, or is it leaving off bedding in an area, or possessions? So there's different ways that they can target homelessness through the PSPO, even if they're not specifically using the word homelessness. It's again, and that resonates, of course, with the vagrancy provisions of the past and the attitude of the past, targeting activities associated with street homelessness. Anyone who, once a local authority decides to issue a public spaces protection order, and to protect quality of life of individuals using that space, they will list those activities, and anyone who breaches the conditions commits a criminal offence. And the maximum penalty is a £1,000 fine, but also fixed penalties can be issued. And the fixed penalties, of course, make it much easier to enforce these provisions. So rather than having to go to court the way you would if with a vagrancy, a criminal offence relating to vagrancy, with the PSPO, the police or the local authority officer can simply just issue a fixed penalty notice. That might be, for example, for £100 typically. So this is how PSPOs we're finding they're being used. It's still, as I said, relatively recent. They were introduced in 2014, and it took a few years for local authorities to become comfortable with them, to understand them, and so when we saw in the initial years not being used that often. But now we're seeing most local authorities have introduced a PSPO. Most haven't yet targeted homelessness. They target a range of different activities, but an increasing number are targeting activities associated with homelessness, which is a real concern.
So what has been the actual impact of these PSPOs on homeless people who might be in these public spaces?
Well, what a PSPO does, because when a local authority decides to introduce a PSPO, and if it targets activities associated with homelessness, such as begging or rough sleeping, they will publish the terms of the order, and this will often include a map demarcating the area that is covered, and as well as publishing them, for example, on their website. They will often target that particular public space that they're concerned about. So it might be a high street, it might be a park, for example, and I've seen billboards being put up listing the terms and conditions of the PSPO, sometimes accompanied with the map as well. And that's just by its mere presence saying to the homeless, you're not welcome here. So even if it's not enforced, it's a very visible statement that you're not welcome. And so the idea of marginalising the homeless, because the thing about law is it's not only in its enforcement that it can have a detrimental effect on minorities. It's actually by its mere presence. And here we're seeing a physical manifestation, a physical presence, that the PSPOs can have that chilling effect, that isolating effect for homeless people. So there's that issue. PSPOs also give local authority and the police and other individuals who will be enforcing these orders the discretion then to say to homeless people, you better move on, you better leave this space, otherwise we'll issue you with a fine, a fixed penalty. So even if they're not actually criminalising or even issuing a fixed penalty to a homeless person, they're moving them on. They're removing them from this space. So that's another issue in terms of the idea of banishment of homeless people. And then, of course, ultimately, PSPOs can be homeless people. If there's a PSPO covering activities such as begging or rough sleeping, those homeless people can find themselves issued with a fixed penalty, or even ultimately taken to court and issued with a criminal conviction.
So why is it that these local authorities are using PSPOs to target homelessness? Is this just an example of, they weren't aware of the effects, or do they find that this is an effective tool that they think will address the issue of homelessness?
Well, it's interesting to know. It's an interesting question. Why are they introducing them? Because we already have the vagrancy legislation in place that dates back to the 19th century, and it's never been repealed, and it's still enforced by the police in England and Wales. It no longer applies. It was repealed as it applies to Scotland. So why bother introducing further legislation and orders that would criminalise homelessness? It's a good question. Well, PSPOs are easier to enforce than vagrancy legislation. To enforce that 19th century legislation, only, first of all, can be the police that can enforce it, so the local authorities are not able to enforce it themselves. And that limits who is able to enforce it. And of course, fixed penalties can be issued for breach of a PSPO. Fixed penalties cannot be issued in relation to breach of vagrancy legislation. So much easier to enforce. It's also going back to what I mentioned there about it's a communicative tool. By introducing a PSPO, a local authority is able to say, we're doing something about homelessness. And it's not going to cost them much to pass a PSPO. They don't have to go to court to get one. And really the only cost is in the publicity. And of course, even if they never ultimately enforce it, or do very little to enforce it. And so it's a way of them communicating to majoritarian sensibilities that maybe is not uncomfortable with the presence of people begging and people rough sleeping, whether that be residents or local businesses, and saying, look, we're doing something, we're listening to you, and we're taking action to deal with this problem. And it's much easier to pass a PSPO and say that you're taking action than dealing with the structural issues surrounding homelessness, which can be difficult to deal with, particularly in this era of austerity, where there's been significant cuts to the budgets of local authorities, which makes it more difficult to take action against these in cases of homelessness. And it's also a case where we have an increasing numbers of homeless people in England and Wales. Statistics show that year on year we have significant increases in homelessness. There's different factors contributing to that, but it's in part because of local authority budgets being cut, and the reforms to benefits making it more difficult to access benefits for those who are in the position of needing them, and also making it the government's policy of making it difficult for European migrants to access benefits, which is, again, all these factors increasing the numbers of homeless people. So local authorities are then faced with a growing problem, visible problem of people on the streets begging and of sleeping. And the idea then of majoritarian sensibilities of people saying, I want something to be done about this. And the PSPO is in some ways an easy win for them.
So you talk a bit in your research about some of the worries around a lack of accountability in actually enacting the PSPOs. So can you talk a little bit about that process?
Yeah, certainly. So PSPOs, as I've said, they don't require a court order. So it's not a case that a local authority applies to the court and says, ask permission to introduce a PSPO. And when we think back to interventions such as the ASBO, a local authority might have applied for an ASBO against an individual, but they had to apply to a court. And the court had to be convinced of the need for an antisocial behaviour order and then subsequently to grant it. So that provided oversight, not always effective oversight, but it did provide oversight. With the PSPO, it's not a court order, the local authority issues it themselves. It's when you talk about a local authority issuing a PSPO, people often think, well, that must mean that all the councillors get together and vote on introducing a PSPO and have that sort of collegiate decision. And there's democratic accountability and democratic scrutiny. However, research by Appleton, dating back, I think, to 2016, found that often, in many cases, it isn't a full council that's voting on this PSPO, and there's no requirement in the legislation for that to be so. It's not even often a committee of the council, but the council has delegated to an individual, to a civil servant within the council to make that decision as to what the contents of the PSPO will have. So we're talking about, in some cases, one person deciding the contents of this PSPO, and that may or may not require further approval from a committee of the council. So there's a lack of democratic accountability there. And research has shown that where local authorities do put the PSPO to a full council vote, that those more draconian conditions, such as those that target homelessness, are less likely to be passed. So where there is accountability, where there is scrutiny, the PSPOs are less draconian. Another problem with the PSPO is that it requires a local authority to consult, but it doesn't have the stipulations that we would expect with a consultation. It has fewer requirements than a consultation on planning provision, for example, fewer requirements for consultation when it comes to bylaws as well in England and Wales. And so a typical way for a local authority who's considering introducing a PSPO to conduct a consultation is to do one online. And having sampled them as part of my research, the consultations, there's no set format, but having looked at the format of some recent ones, it tends to be that those who are completing the consultation just see a list of behaviours, such as begging. And those responding to the consultation are asked to rate to what degree they believe that begging is a problem. The risk with that is that, of course, by including them in the consultation and saying, is begging a very big problem, no problem, for example, is it encourages those completing the consultation to think, well, it must be a problem if it was included in the consultation to begin with. And it also, the way the consultations are written, is a temptation then for people just to think, well, I should take that it's a big problem because that means something's more likely to be done about it. So there's a problem then with not only just the democratic accountability, but in the way the consultations are gathered as well. Another issue in terms of accountability is that with bylaws that in England and Wales, when a local authority passes a bylaw, they have to submit it first to central government, and central government then has some say on an oversight of the bylaw, and a list of bylaws is then maintained by central government. There is no need to submit, and there's no facility to submit a PSPO or a proposed PSPO to central government. So there's no oversight from central government, and there's no set list for individuals such as myself, researchers wanting to scrutinise the use of PSPOs, to go and have a ready access to all the PSPOs in the country. I've had to, as part of my research, approach each local authority in turn, ask for their PSPO, ask for their consultation documents, ask for their associated policy documents, which is quite a slow, cumbersome process. So there's not accountability from researchers either. And then for those who wish to challenge a PSPO once it is in place, the government framed the legislation to make it difficult to challenge them in the courts. So individuals who wish to challenge them have only a certain number of weeks to challenge the order. That makes it difficult if someone arrives into the area outside of that period. I think it's 6 weeks from memory. Then they're left with only the option of getting the support of organisations, NGOs such as Liberty or Crisis, to go through the judicial review route. But that can be expensive. Can be expensive and often doesn't yield positive results. So again, there's a lack of judicial accountability. So on all the different forms of accountability and scrutiny, PSPOs are deeply troubling.
The PSPOs were part of a push to make local governments take more responsibility for addressing social issues. So do you think that push is a good one? Is this just an example of a good idea implemented very poorly? Or do you think that the central government needs to take more responsibility for this?
Well, a key theme of David Cameron's government under the Conservative Party, but also then in coalition with the Liberal Democrats, was this principle of localism. And he talked about, connected to the idea of the big society. And localism was this idea that we should devolve powers from the central state to as low a level as possible, so that citizens and communities feel more involved in their day-to-day lives, can make decisions that impact on their day-to-day lives. So this PSPO fits that narrative very well. It's it's saying we're going to trust local authorities to decide what behaviour impacts on quality of life in their localities, and that different local authorities will have different issues. Different communities will have different ideas of what's acceptable or unacceptable in public space. And that was, of course, one of the reasons that they didn't introduce this central government scrutiny or other levels of scrutiny, because they felt let's leave it up. We can trust local authorities, we can trust local communities to determine what the contents of a PSPO should be. And it's been interesting because a couple of years after introducing the Public Spaces Protection Orders, the Conservative government introduced the Homelessness Reduction Act in 2017. It's only came into force in April 2018. It's only just come into force. It governs England. And it places obligations on local authorities, again, this idea of localism, but local authorities to take action to reduce levels of homelessness in their localities, and places responsibilities on them to do so. The central government has also promised 1.2 billion of additional spending to support local authorities in dealing with homelessness. So the government has recognised that homelessness is an increasing problem. I mean, the figures are testament to that. So there's no denying that. But I think it's an interesting juxtaposition that on one level they're saying homelessness is problematic. We need to support those who are homeless. We need to place obligations on local authorities to do so through the 2017 Act, and we're going to provide additional funding to help them. But also at the same time facilitating through PSPOs local government taking punitive action against those who are homeless. Now, I would say that the reason that we have this contradiction is, yes, the government have more recently taken a more traditionally welfareist response to homelessness through the Homelessness Reduction Act, this idea of providing support. But this is very much in the context that we've talked about, this idea of seeing the deserving and the undeserving poor, apportioning blame to those who are not in work or those who find themselves homeless. This idea of the anti-immigration attitude, the context of individualism as opposed to a more communicative, some communities working together to tackle social issues. And to this problem, this sort of more neoliberal attitude, pervasive attitude, sits uneasily with the government's supposed concern for a welfareist response to homelessness through the 2017 Act. So they're sending very mixed signals to local authorities. They're saying through the 2017 Act, a welfareist response is important and is key. However, by through the more general neoliberal debate and narrative that has permeated through central and local government over the last decade, they're sending out the signal: you should apportion blame to individuals and you can take punitive action. And so I think that's why you're seeing some local authorities, an increasing number of local authorities, targeting the homeless through PSPOs.
So part of this debate centers around too about how we want to, or how we think we should interact in public spaces. And I think a lot of what we were talking about is reflected too in the rhetoric around gentrification. So how inclusive should public spaces be? So do you think that these PSPOs are part and parcel of this debate around gentrification and how we should have public spaces? Should public spaces be more inclusive, or are we just displacing poverty and homelessness?
Yeah, so gentrification is an interesting issue because this is not, because it doesn't just affect the UK. There's discussions about gentrification throughout a lot of the Western world, and big debates about it in America, in for example in New York and places like Brooklyn. And gentrification can be seen as a positive, and originally it was seen as a positive in the sense of, communities that have high levels of crime and disorder, where the housing stock may not be in particularly good shape, where there's not great local amenities, where there's a lot of graffiti and damage to facilities such as parks, and that through gentrification you improve these areas. They improve the standard of housing, you improve the cleanliness, you reduce crime, and then you encourage more people into the community, individuals who have a desire to improve the area further, and you sort of have this sort of positive feedback of, as the area improves, more people come in and the area gets better, and so on and so on. But more recently there's been greater discussion about the negative effects of gentrification, that it isn't purely a positive experience or a positive phenomenon. And that is that people can feel excluded through gentrification, that the original residents of an area, and often areas that are gentrified are areas that would have high social housing populations, then feel that as rental prices rise and as mortgage prices rise, that social housing stock can be sold off, or those who maybe were privately renting but could only afford a certain level of rent then are excluded from those areas because of those increasing rental values. And areas can become less diverse, so there can be racial disparities where you have more white people moving in to areas. There's been a discussion in Brooklyn, for example, and what was a traditionally largely black population is being increasingly displaced. And this, then, if we go back to the focus of our podcast today, homeless people gentrification can have a negative effect on them as well, in that areas where people, first of all, maybe are made homeless because of gentrification, because of the reduced affordable housing in that space, but then also there's more of an intolerance as more sort of middle class sensibilities that are uncomfortable with the presence of homeless people begin to predominate in those areas, and so homeless people can feel completely excluded, and through interventions such as PSPOs can be completely excluded from those areas.
So what do you think should be done about PSPOs? Or do you think they're a good idea, implemented poorly? Should they be repealed, got rid of completely? What would be your ideal scenario?
I think we're waiting for, I suppose, as I said, they're relatively new, and they're becoming increasingly popular. So there's more and more of them about, and we're waiting for sort of cases, particularly within the higher courts, to examine the validity of some of these conditions. I don't think we'll ever get a court case saying that PSPOs per se are illegal or in breach human rights, but the certain conditions do. And I think over time we'll get a greater sense of what's acceptable and unacceptable, what the courts are prepared to view as unacceptable conditions. The problem is that will take time, and because PSPOs differ so significantly from local authority to local authority. So one local authority might target begging by just having a blanket provision saying no begging. Another local authority might say no aggressive begging and define aggressive begging. What happens if a court strikes down a provision on the first local authority that criminalised begging through the PSPO? Does that impact on the other local authority who just criminalised aggressive begging? So it can take a long time for the courts to sort of help set the boundaries of what's acceptable and unacceptable when it comes to PSPOs, and particularly because of the difficulty of mounting legal and court challenges to them. But I think we will see these come through the courts more frequently in the next couple of years. I would like to see PSPOs potentially have their uses. This idea that we might have a shared idea of how we wish to use public space and improve public space for everyone. So I don't think necessarily we should scrap PSPOs, but I think greater protections need to be put in. So the government, there were a number of amendments proposed during the passage of the legislation to introduce PSPOs, which I think could improve them. And one of those would be to improve the level of scrutiny of PSPOs and when they're proposed. So you could, for example, amend the legislation to say that there needs to be a vote of the entire council. It must be a vote of the council chamber on whether a PSPO should be passed in an area or not. So that would increase levels of democratic scrutiny. You could amend the legislation to make it easier to mount legal challenges in the courts to PSPOs. So that would also be of benefit. We could stipulate in the legislation that certain provisions are not permitted. The government has recently sought to clarify in an updated version of the statutory guidance covering PSPOs, that homelessness per se should not be covered by PSPOs. The difficulty of that is homelessness generally isn't. I haven't seen a PSPO that just uses the term homelessness. It's usually activities associated with homelessness, and the guidance doesn't mention. The reformed guidance doesn't say you can't continue to use PSPOs to target activities such as begging or loitering, for example. And it talks about, it sort of gives advice that maybe they shouldn't be used to target rough sleeping, but it doesn't explicitly say that they can't be. So I think clearer statutory guidance on this would also be of benefit in sort of restricting this misuse of PSPOs as I would see it.
So we've heard a lot about how local authorities are using defensive or hostile architecture in order to structure public spaces and exclude certain populations. Could you talk a little bit about how that impacts the issue of homelessness?
Yes, it's an increasing concern of charities such as Crisis about the use of this hostile or defensive architecture. And what this entails, there's different examples of it out there, but it's making spaces unpleasant for those who would be wishing to sit down or to lie down within those spaces. So an example we have seen in Belfast through Belfast City Council is the removal of park benches or the placing of armrests in the middle of the park bench. So not just on the two sides of it, but in the middle, making it impossible to lie on that park bench. And though that's architecture changes to furniture or changes to floor space, for example, floor space putting in studs, metal studs, so people can't lie within doorways or under archways, is designed through the architecture itself to exclude individuals. And I think that's very symbolic of our approach to homelessness, that we're actually altering and amending our architecture to exclude them.
So finally, we hear on the news a lot that homelessness is rising, especially in reference to places like Edinburgh, where they say they were very close to eradicating rough sleeping. So what are actually ways that governments can address homelessness?
I think it's difficult to completely eradicate homelessness, and of course, as I said, we've talked about there's different types of homelessness that we're dealing with, and there's different solutions that need to be offered. But making sure there's affordable housing is available, and for social housing, inclusive supportive social housing for those who need additional supports to maintain a life living in an apartment or a house. Also, that the benefit system. That we had the severe problems that we're having now, where individuals may not receive their benefits for weeks or months, leaving them destitute. That the benefit system is reformed so that individuals are no longer having to live without any money or live purely on charity, and would be a great help. And then also working supportively through welfarist solutions to deal with homelessness, because I think what we all agree is that there shouldn't be a need for anyone to beg on the street or to sleep rough on the street. But my criticisms of PSPOs is not that we should, that people should be left to beg or to rough sleep, and it's not a cause of concern. It is a cause of concern, but it shouldn't be a punitive solution to this issue. It should be a welfare supportive solution. These individuals often have very complex lives. They require a lot of support. They require different levels of support depending on the structural factors or the personal factors that have led them to be homeless. But through investment, through best practice, through seeing it as a need to support these individuals as opposed to punish these individuals, I think that is the way for us to reduce homelessness.
Well, thank you so much, Kevin, for taking the time to speak to us today. I hope our listeners are a little bit more informed about what on earth PSPOs are and how to better address homelessness.
My pleasure. Thank you very much.
You have been listening to Law Pod, an informed take on current events brought to you by the law students and staff at Queen's University Belfast. This episode was produced by myself, Richard Somerville, Rachel Colleen, Julia Hunter, Rachel Lynn, Joanne Tang, and Daphne Lim. Our theme music is by Colonel Chocolate and the Justice Triangle. Law Pod is funded by Queen's Law School and the Queen's Annual Fund. Thanks to our guest speaker, Dr. Kevin Brown. You can follow us on social media. We are on Twitter at QUB LawPod. For more information, you can visit our website, lawpod.org, and please have a look in the show notes for more information about the topics covered today. You can find us on iTunes or anywhere else you get your podcast. Thanks for listening. I'm Alina Utrata, and this was Law Pod.